The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before the court are admonished to draw nigh and give their attention to the court now sitting.
Please be seated. Good morning. We welcome all of you to the Kansas Supreme Court, both those of you who are in the courtroom and those who may be watching through our live stream. We do have an empty chair this morning, as we have had all week. Justice Evelyn Wilson is not participating in this week's docket, which means she will not be hearing the arguments today, nor will she be participating in any other way as we reach a decision on these cases that we're hearing this morning. So we have read the briefs and other parts of the record and made our own notes and are prepared to and look forward to the arguments of counsel this morning. With that, I would ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the ninth.
Thank you, Your Honor. Please swear. The first case on the 9 a.m. docket for Thursday, May 15th, 2025 is appeal number 127038, State of Kansas versus Raymond Cherry, Johnson County, briefs both sides.
May it please the court, Peter Meharry on behalf of Raymond Cherry, present and ready for argument. Thank you.
May it please the court, plaintiff appellee, the state of Kansas by Assistant District Attorney Kendall Kaut, present and ready for argument.
Thank you.
Second case is appeal number 126491, State of Kansas versus Robert Cameron Grant, Sedgwick County, briefs both sides.
May it please the court, Robert Grant appears through counsel Jacob Nowak of the Appellate Defender Office, present and ready for argument.
May it please the court, Christy Allen, Assistant District Attorney appearing on behalf of the state of Kansas, present and ready for argument.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima. Will counsel on 127038, State of Kansas versus Raymond Cherry, please come forward. Mr. Meharry, you may take the lectern whenever you wish. Within reason.
Thank you, Your Honor. May it please the court, Peter Meharry for Raymond Cherry. I would request 3 minutes of my time for rebuttal, Your Honor.
3 minutes is granted.
Thank you. This case comes before the court on my client's appeal from his conviction for various counts, the most severe being a felony murder charge, which he was sentenced to a hard 25 sentence for. Those charges arose out of what we often say is a drug deal gone bad. The state alleged that my client, along with two other individuals, conspired to rob an individual, thought he was going to sell weed, but during that drug deal, things went south, a fight ensued, and the person who was trying to sell the weed was shot and killed. The state's theory was that my client was one of the two people that entered the apartment. There was a third co-conspirator that was outside in a waiting car. My client brought a defense of alibi. He testified that he was home on that day in question, as well as his wife, who testified to the same thing. So the question at trial was who more so than what. And in this case, we've raised several issues that we believe show that my client did not get a fair trial in this matter. First issue we've raised deals with statements the prosecutor made in closing arguments. The prosecutor repeatedly used the phrase, we know. As this court knows, this is kind of loaded language that this court has said you cannot use for various reasons. Number one, that it does imply that the prosecutor may know things that is not presented to the jury. Also brings kind of the weight and credibility of the state behind it and pushes the jury to just follow the state's lead instead of objectively reviewing the evidence for itself. As I said, that state used this language multiple times and it dealt with what we believe are contested facts so that it was improper to do so. The state has noted a couple of the times the "we know" language was used as a question as opposed to a statement. We don't believe that makes any difference. Whether or not you say, how do we know it was Joe because of this evidence is no different than saying we know it was Joe because of this evidence.
Wouldn't it have made any difference if the prosecutor had said, how do you know that it was Mr. Cherry?
Maybe. I think there's a difference between saying you know and we know. And I think the court has said the problem with the we know language is kind of the state is including itself, giving its opinion, putting the weight of the state behind it.
The reason I asked, that's the answer I thought you'd give, but it seems to me there's a difference when the "we know" is put in a question the way it is here, as opposed to "we know," because then it is the weight of the, I'm not trying to change the law. We know it puts the weight of the state behind something that is a disputed fact. But here, when you say, how do we know? It doesn't seem to have the same punch. So why do you think it has the same punch?
I think it has the same punch because when you're using we, you're including yourself. We know, as opposed to, I think there's a difference with you.
One's a declaratory statement, the other's still a question. And that's what's hanging me up here.
And again, I think there is no difference in saying, how do we know because of A, B, and C versus we know because of A, B, and C. The prosecutor is still using that we know language that includes himself, includes the state. How do we know? Me, the state, all the police that investigated. How do we know this? Because of A, B, and C. So I don't think phrasing it as question mitigates the problems this court has noted with using that loaded language.
It's the answering the question, right? I mean, it's the question with "we know" coupled with the answer that makes it that powerful, is what I'm hearing you say.
I agree, and that, just as if you would make a statement, we know because of A, B, and C, it's because you're combining them, you're combining the states, the weight of the state behind this evidence. And I think you're doing the same thing, even if you phrase it as a question. So I think regardless of how it was said here, whether or not it was a statement at times and a question at other, it is error and problematic because, as this court has said, it puts this weight of the state behind it. It implies maybe there's things that the state knows that wasn't presented to the jury and would push the jury to just accept what the state is saying.
Can I,
Another,
go ahead, sorry.
just to make sure I'm understanding what you're saying, is another way to say this is that we often say that we consider prosecutorial error in the context. We have to look at the whole context. And when you look at the whole context, essentially, under your view, what the prosecutor is doing is using that as a rhetorical device to say, I know this for these reasons. Is that?
I mean, I think the prosecutor is saying, we know this. And me, I know this as a representative of the state knows this. So it's putting everything, all the weight with the state behind this evidence, kind of propping up this evidence for the jury with the weight of the state. He didn't say, I know, but I think by saying we know, he is including himself when he's making those statements in front of a jury.
Just want to be clear as to what your claim actually is specifically. I think I counted 4 specific "we know" statements that you claim are error. Are there more than, and I can go through each one.
I think that is correct. The sites I have, there was a couple times on record 44, page 170, where he talks about we know from their testimony when he's talking about the co-conspirator testimony.
Yeah, so if you don't mind, I can just real quick walk through it. There's the "we know" from the testimony. Then there's the "how do we know it was Ray Cherry," right?
Correct.
And then there's "why do we know it was Ray Cherry?"
Correct.
And then there's one other reason we know it was Ray Cherry.
Correct.
There aren't any other, you don't make other specific claims of error
With,
from other parts of the argument. Those are the four statements we have to evaluate.
that's correct.
Okay.
That's what I raised in the brief, and that's where I believe the state did err in using that, as I have said, loaded language.
That's helpful just to narrow the universe of what we're talking about.
Sure.
I just want to ask a quick question on the first one about the testimony regarding the convenience store.
Mhm.
Prosecutor says, we know they went in, we know they bought cigars, we know what he was wearing. Our case law suggests that we know language can be used when the test or when the evidence is uncontroverted. Given the fact that there was video evidence that showed this exact sequence of events, was that really controverted?
I would argue it was. I think there's a difference between having evidence to support the statement and being uncontroverted. And here, my client, his defense was, I was home with my wife. Wasn't
Right, but
me.
I'm sorry to interrupt, but this we know statement isn't about your client, right?
No, but it is about the co-defendants. And I think when you start saying, even if they have other evidence to support it, my client is calling everything into question when he pleads not guilty. He's calling everything into question as to, particularly, I think, the co-defendants, because they testified it was my guy. Ray was the one who was there, who was a shooter. My client saying, I was home.
Was there ever any evidence that specifically contradicted the idea that Hicks went inside, bought cigars, and was wearing a sweatshirt and hoodie?
I don't think there was evidence specifically toward that point. I think just generally speaking, my client was challenging everything the state was arguing with his claim of innocence. And that's why I think it is not uncontroverted. It may be supported by other evidence, video evidence, but I don't think that just in itself makes it uncontroverted. So I think it still was an issue at trial, and certainly the co-defendant's testimony figuring my client was an important part of the state's case. And when they get up in closing argument and start saying, we know they did A, B, and C, in effect, the state is kind of vouching for their testimony. Now, certainly it points to other evidence to support that. But I think when you start going into that and saying, we know they did this, it lends credence to their testimony, which in turn, the flip side of the coin is it hurts my client's defense. So we believe it was error in that instance as well. With the time remaining, I would like to touch on the second issue, which is display of the gruesome pictures in this case. There were multiple autopsy pictures, multiple scene pictures that were admitted without objection. However, during the display of one of the pictures, there was an objection to the extended time period where it was displayed to the jury. And I think that when you look at the probative value of this evidence, which we would argue was limited, given that the question of the day was who did this as opposed to what happened, the extended display of the pictures of the deceased at the scene was overly prejudicial. The district court, when defense counsel objected, saying that this was overly prejudicial for leaving it up for an extended period of time, the district court essentially said, well, that's a pretrial issue and didn't do anything to mitigate it. We believe that that was an error.
I understand that you made no objection and you don't pursue a claim on appeal that the photos were inadmissible for any reason.
That's correct.
Your only claim is that they were displayed for too long.
Correct.
Is there any case that suggests that the length of time that admissible evidence is in front of the jury can create any kind of prejudice or error?
Admittedly, I did not find one, Your Honor.
I mean, it seems
If I did,
counterintuitive. If it's admissible, why can't the jury look at it for as long as they want?
I think that there is a point where it becomes overly prejudicial just to put it in front of the jury's faces for an extended period of time, even if it is an admitted exhibit. Because again, you have to look at the probative value and prejudicial impact. And why or what would be the purpose of just showing this picture forever?
But wasn't that analysis already done when the pictures were admitted into evidence? Is the probative versus prejudicial some sort of ongoing test that lasts forever throughout the trial?
I think depending on how, and this probably goes for the defense too, how the state uses an exhibit can raise those issues. And here, I think the extended display of this picture in front of the jury was overly prejudicial. Again, the question wasn't what happened. No, I mean, this was blood splatter evidence. Frankly, I don't know what the point of that testimony was in total, because nobody was contesting that. So it has limited probative value, but it is a gruesome picture. It shows a young kid who was shot and killed. And jury, we may see this stuff pretty frequently. Juries don't. And as defense counsel noted, he saw the jury's faces when they were looking at these pictures and the impact that they had. So the extended display can become overly prejudicial such that the district court should have taken action.
When you talk about display, no, I cut you.
Go ahead.
When you talk about display, just help me. We have different courthouses across this state. What was the display? Was it a screen? Was it publishing photos to the jury where they hand them around? We have a great variety of how they're displayed. How was it here? And maybe Mr. Cowton would know that also. I'm just curious more.
Yeah, and he may know better than I. My understanding was it was displayed on a screen.
On any screen?
I don't know if there's more than one.
Okay, I just want to.
My understanding is
what visual kind of impact this would have on a jury or a juror who's sitting 10 feet away. It's right in front of their face. I'm curious of how that.
My understanding is that they have large screens that they project images on in Johnson County.
Okay.
That's what was done here.
Well, sounds to me like, I don't know, maybe this is an extension of Justice Stiegel's questions, but it doesn't strike me as well suited for our evidentiary frameworks to assess this argument. Is it better suited as a prosecutorial error claim?
Maybe. I raised this as an evidentiary issue,
right?
Kind of, because it's actually the use of the evidence. And the objection at trial was that specifically this has been displayed for an extended period of time. It's overly prejudicial and has a pretty big impact on the jury. And that's how we've argued it on.
And yet the jury would have had it in the jury room, and we have no idea how long they might have looked at exhibits or how the exhibits might have been used there.
I think specifically with this one, if my memory is correct, it was a demonstrative exhibit. And I don't know that it was sent back, but I think there was other similar pictures that would have been admitted and went back with the jury. But I think the one on display when the objection was made, I believe, was the demonstrative only.
All right.
But if the others were similar and they went back in the jury room, where's the prejudice?
I think there still is prejudice from displaying it in front of the jury for an extended period of time, given the impact it would have. And it would push the jury to look at this as a terrible crime and someone needs to be punished. And that pushes them away from looking at the issue at this case, which is who was the second person in the apartment. Thank you.
Thank you.
May it please the court, Kendall Cout for the state of Kansas. I'll start with issue one, but I definitely want to make sure I answer the question you had, Chief Justice Lukert and Justice Rosen, that you had once we get to issue two. So I'll make sure to address those, but I'll start in the order that was brought up by the defense in this case. We would certainly agree there are 4 instances or paragraphs of we know. We've conceded one of those we know instances under the more recent framework from this court would be error. And so we turn to that second step of the prosecutorial error analysis in our post-Sherman framework. The first one, I think clearly though, meets what is allowed under we know in that wide latitude that a prosecutor is allowed. The evidence is uncontroverted that Alan Michael Hicks went to 7-Eleven and that he was also at the Quick Shop. There is a video of Mr. Hicks at that Quick Shop. It's clearly his face. He's buying cigarillos. I think he hands some paper money over to the clerk who's working at the register that day, and he doesn't get change back. And we know it's him depositing that hoodie in that storm cell that's eventually recovered by Brianna Stewart. And there's that photo of her coming out where she's halfway up, which is a little bit unique in this case. But we know from that Ring camera footage that Mr. Hicks deposits that hoodie, and from the DNA analysis that shows it's in the octillions, that it's his DNA on that hoodie and that firearm that's deposited in that storm drain. I also think on the question of, well, what's uncontroverted evidence, yes or no? It'd be too broad just to say, well, the defendant challenges every element of the crime, therefore everything is controverted. Well, if that's the standard, then there would be no uncontroverted evidence, which would run afoul of recent precedent this court has had when assessing these we know statements. When we look at what happens in this case, then I think we turn to are questions in and of themselves, or at least the questions in these specific instances, evidence of prosecutorial error. And I think the test for how questions are viewed by this court post Alfaro Valea, the 2022 case where the state tried to say, can we get back some leeway on we know is within the wide latitude, and this court said, no, we're still going to hold you to we know can be prosecutorial error if it's not at least uncontroverted evidence, or if the state's trying to draw an inference from it, then we know is not appropriate. In this instance, I think it leads to what I would say is that sometimes the Sherman two-step analysis of what's within the wide latitude, then we shift to, is it harmless under the constitutional harmless standard, sometimes can get blurred a little bit. And so whether this court says, hey, in this instance, these we know statements are error because we feel these questions are just a little bit too broad or do require that reasonable inference or not, ultimately, I think it's still going to be harmless. And if the court wants to engage in a discussion about that, I'm happy to, for why we think it's within the wide latitude. We briefed on this issue. I think our best point would probably be there's a question. In that first instance, how do we know that it was Ray Cherry? Do we know that only because Mike Hicks and the driver told you that it was Ray Cherry? No. And then there's a statement there. And in that second one, why do we know that it was Ray Cherry? Because the because the fiance told you that it was Ray Cherry. She came into this courtroom. She started testifying. Whether the court feels that's error or not, ultimately, it's going to be harmless under that second step of the Sherman analysis. And why I think it's clear that that is harmless is I have been unable to find any case where the use of we know by a prosecutor has not been held harmless by this court and by courts of appeals and those panels throughout Kansas. And in this instance, when we look at the evidence and we look at what's contested in the case, Mr. Harris, the defense counsel for Mr. Cherry, did not contest that his client's DNA was on that cigarillo that's left outside the apartment. The only argument against that is, well, he'd been smoking with them a few days earlier when the Chiefs had their first AFC championship game in the Mahomes era, and that's why he has his DNA on that cigarillo. Not a very compelling argument, though, when he at first told the detective, I don't know these people, directly contradicting his statement, or why they would choose to smoke a cigarillo that is old and has been put in the ashtray 3 days before when the Chiefs would have played the Patriots in the Super Bowl, instead of using their brand new cigarillos, why they would go back to a cigarillo that somebody that's not with them has already smoked, why the fiance of the victim would say, that's the shooter, why they would pinpoint someone else differently, and perhaps most importantly, why they would drive to a 7-Eleven that backs up to the apartment to the defendant. Why would they go to another gas station? Why would there be two gas stations on this journey in this case, unless they were picking up somebody that lives right behind the gas station, which is where Mr. Cherry lives? So all of that evidence coupled together is so overwhelming that it would be hard in this case to say that those just few we know statements are what moves the jury, and ultimately this court would be able to say beyond a reasonable doubt those brief statements did not impact that jury's verdict. Beyond that, this is a 7-day jury trial. And in some of the court's recent precedent, whether it be State v. King, whether it be the Brown decision, whether it be Alfaro Vallejo, there's been pointed out it's brief statements in a week-plus trial or in a long trial. It's hard to believe with all the evidence presented with all the testimony of witnesses, that what would decide the case for these jurors would be a few we know statements that are made in these paragraphs. So in that instance, that's why we believe, regardless of how the court comes out on the question of, is this we know statement just a little too afoul of the first step in the Sherman analysis? And we have our arguments for why not that I think we've presented with our briefing. But even if that's the case, to say this would be the first case in Kansas when the evidence is so overwhelming, the trial is so long, and additionally, what's been pointed out in cases like Alfaro Vallejo is when the jury is instructed for those pick instructions on things like, it is for you to determine the weight and credibility of the evidence. And when there's a mention that statements, arguments, and remarks of counsel are not evidence. Both of those instructions were given by Judge Draghi, and in State v. King, the 2018 case that this court ruled upon, that was held to be important in the analysis. You couple the importance of those pick instructions with Mr. Benefeld beginning his closing argument by even highlighting those instructions, and it would seem that satisfies any concern with harmlessness under this test.
It sounds like what you're saying is that there are cases out there, and we're pretty clear that we know is error, you know, in certain cases, but that it will never be reversible.
Justice Stanbridge, I am saying in instances like this, it will not be. The example I could think of, Justice Stanbridge, would be if somebody stood up and said, we know he's guilty because we have evidence you haven't seen. I think that'd be an instance where the we know is coupled and problematic. Or if the prosecutor would say, we know he's guilty because I've looked at the files, or we know he's guilty because we can really trust this witness and believe them for how stoic they were, and that's why you trust them, which would also run afoul under prosecutorial
Isn't
error.
that kind of what happened? You know, I mean, it was controverted about the identity, and he said, we know it was him. And so basically, isn't he vouching for the witnesses, what the witnesses said?
Justice Stanbridge, I don't believe he's vouching for the witnesses in closing because I believe it is tied directly to the evidence as opposed to providing vouching that exists outside of the evidence. So I think it's the tie into this is what they testified to. Here's the substance of their testimony that differentiates it and allows this court to say, if there were to be a line where we know becomes not harmless error or reversible error, it would be not tying it into the evidence in the case and providing some external validation that's not present.
But I mean, when you were arguing, you went through and said, basically what you're saying is that we know was justified because his version of the story was not credible.
Justice Stanbridge, I'm saying it's justified under harmlessness because it's not credible. I think under the first step, if the court said, hey, there's some vouching, or the question is at least an inference that might run afoul under the post Alfaro Vallejo. So I think I'm more focused on that second step, and that would be the distinction I would hope the court would draw under this case. If there are no additional questions under that first issue, I'm happy to turn to the second issue related to the blood spatter analysis from the slide. Just to address at the top the two questions, I'll start with the one Chief Justice Lukert you had. This particular exhibit that was objected to by Mr. Harris was just the demonstrative PowerPoint. So that one would not have gone back to the jury. Justice Biles is correct that there was very similar evidence admitted that next day, and those would be States Exhibits 61A and 61B. So it appears to me from the reply brief that all Mr. Cherry is objecting to is slide 21 of that demonstrative Exhibit 59, which is the blood spatter PowerPoint that has gone over by Mr. Morris. If that's the case, 61A and 61B in the admitted exhibits are just a rotated version of showing the gunshot to the victim. So if there is some concern about prejudice, first, there is not a contemporaneous objection, which would be necessary, we know, under KSA 60-404. And second, it would still be presented to the jury. So if there's some risk of prejudice from showing it to them, as Chief Justice Lukert mentioned, they would have that back with them. And as Justice Biles mentioned, they'd have the opportunity to consider it back there and weigh that. To consider the question of Justice Rosen about how's the setup in Johnson County or what are the screens like, the new courthouse opened in Johnson County in 2020 in December, moved our stuff over in the COVID era, had some nice people help us with that. And the way it works in Judge Draghi's courtroom and in our courtrooms that can hear criminal trials is that there is a podium you can go up to that has a screen. The witness testifying has a screen in front of them that's like a computer monitor you would have, or if you hook up a third external monitor to see things. And then each juror who's in the box has a screen in front of them that they can see. And those are situated in most courtrooms where there's one screen in between every two chairs to save a little bit of money, not having 14 screens, because most of our boxes can seat 14 plus people in case we have alternates in some of our bigger trials. So there generally would have been about 7 screens for the respective jurors to look upon. My guess is those are probably about 12 to 15 inch size monitors that they would have been able to see that day. There's also a high definition television that is behind the witness stand. From the record, it is unclear to me if that TV was turned on. My experience trying cases in Johnson County post the new courthouse, sometimes we turn those TVs on, sometimes we don't. That relates to maybe if there are family members in the gallery, we don't want to have them see their loved one on the screen, or maybe they don't want to see certain evidence, but we make sure it's available for the jurors. So I can't tell you in this case if that was presented to the whole courtroom on a giant screen, but they would have had it on monitors in front of them. Ultimately, regardless of what happens here, I believe the issue is waived by the admission of 61A and 61B the next day. Certainly agree with the line of questions presented by Justice Wall and Justice Stegall about objections under the probative versus prejudicial analysis that's set up by case law and is set up under federal rules of evidence this court's adopted for decades, would be that objection cannot just be satisfied by saying it's been up too long.
So let me ask a little bit about that. You would agree that there was an objection at trial that these have been up too long?
Agreed, Justice Stegall.
And it's framed on appeal as kind of an evidentiary objection, which makes us think of weighing probative versus prejudice and all that. What if that's not really what the objection was? It wasn't an evidentiary objection per se. Could it have been, and I'm trying to think about, does a district court have the ability to just essentially control the courtroom where you have admitted evidence, but the defendant basically says, look, judge, that's been up for 2 days. Can't we take it down? Is that a reviewable? I mean, how would we review that kind of a request and ruling by a lower court?
Sure. So Justice Stegall, I do think a district court judge has the authority to manage their courtroom, run affairs. So I do think if Judge Draghi had said, I'm tired of looking at this, or it's been up too long, he could order it taken down and the parties.
Right. The prosecutor does not have a right to keep a piece of evidence in front of the jury during the entire trial, right?
Agreed, Justice Stegall.
The district court has the authority to control the courtroom to that extent. And why shouldn't we look at this essentially under an abuse of discretion standard in that regard? Because it does seem to me as though a defense attorney can make a reasonable objection to, look, okay, so this evidence is admissible, but it's been up on this screen for 8 hours. It needs to come down. Isn't that a reasonable request? And I know that's not the facts here, but.
So Justice Stegall, hypothetically, I'm going to entertain there could be some instance where that's a reasonable request. I think part of the reason why this probably doesn't come up on appeal much is normally if you're the prosecution, you may not want to put the image up there for 2, 3, 4 days because it might dehumanize your victim. The jury might get offended at you with, why are you just showing us this dead person for a while? But to answer the question specifically, if the court reviewed for abuse of discretion under this factual scenario, I think there is not enough of an objection that would be timely and note things. So
why not? He said that the objection was clear. This has been up for too long. And if it's, and my question is kind of the legal question. If that's not strictly speaking an evidentiary objection, what kind of objection is it?
So Justice Stegall, I think it could be evidentiary. It could be abuse of discretion. As mentioned, since there isn't case law that really goes into this, we're more 10,000 feet. However the court wants to view it, I think we feel comfortable under any standard. Ultimately, what the problem would be here and what I mentioned for why it's not specific enough is I think it's up to district court counsel to say, this image has been up for 45 minutes because I've seen jurors 1, 4, and 7 look perturbed by it. That's the reason why I'm asking it to go down. And then if the judge said, I agree with those factual findings, but I believe that the jury has a right to see this for 4 days if it would like to, then the court could review under its 3 prongs for abuse of discretion, whether there is an abuse of discretion there.
You're out of time, but real quickly, I wanted to talk briefly about the jury trial waiver. Do you agree that there was no jury trial waiver?
Agreed, Justice Stiegel.
And you would just hang your hat on the fact that even if essentially harmlessness, that the defendant received the benefit of the bargain and would have waived his jury trial right?
That is the entirety of our argument on that. You're correct, Justice Stiegel.
Thank you.
And if there are no additional questions, I can see I'm out of time, and I would just ask this court to affirm the ruling of the district court and the jury's finding of guilt on all counts. Thank you.
Thank you. Mr. Meharry, you reserve 3 minutes.
Unless there are questions, I would waive rebuttal and ask that this court reverse this matter for a new trial.
Do you have any disagreement with the stipulation issue? What is your prejudice argument on that issue?
I think the state has to show it was harm. And we don't have anything in the record. There is really no discussion about it that would support the state being able to say, had he been advised, he would have done this. It's the state's burden to show that, and they don't have anything they can point to support their argument otherwise. And I think in the brief, I've detailed a few cases out of the Court of Appeals where they talk about what you can look at, and they talk about it's harmless in this case because there is this discussion on the record between the attorney, the district court, the defendant, et cetera. And we don't have any of that here. So I don't think they can meet their burden of showing that this was harmless. Thank you.
Thank you. And thank you to both counsel for your arguments today. The court will take this matter under advisement, which means that we will begin discussion about how this case will be resolved. Justice will be assigned to write a draft opinion that will be reviewed by the other justices. There may be additional decisions written either as concurring opinions or dissenting opinions. As those work through the process and we reach a final decision, all those writings will be filed with the clerk of the appellate courts and also posted on our KS Courts website. So those decisions are all available for anyone to read and see the reasons that we decided the case in the way we did. We often note that this is one part of the judicial process that really sets us apart from the other two branches of government. I'm sorry, in that we do provide that transparency of the reasoning for our decisions and how we reach those decisions through that written decision-making process. So thank you for that. As I close with my little civics lesson, I'll thank counsel. And we'll ask counsel in 126491, State of Kansas versus Robert Cameron Grant, to please come forward.
May it please the court, Robert Grant appears through counsel Jacob Nowak of the Appellate Defender Office. Chief Justice, may I please request 3 minutes of my time to reserve for rebuttal?
3 minutes is reserved. Thank you.
Thank you. Tuesday of this week marked 4 years that Robert Grant has been incarcerated for crimes that he, as an 18-year-old, could not commit as a matter of law. See, when our sexual exploitation of a child statute was first enacted, we didn't have modern smartphone technology, and so it wasn't aimed at criminalizing high school sweethearts sending each other pictures. It just so happened that that conduct fell under the prior version of the statute. So in 2016, our legislature addressed the rise in consensual teenage sexting, amended our sexual exploitation of a child statute, and enacted a pair of Romeo and Juliet teenage sexting statutes. Those statutes either render conduct legal or misdemeanors or felonies upon subsequent or aggravating factors. It starts with anyone under the age of 19 who possesses a photo of a child in the nude who is 16 or 17 years old, that is not unlawful conduct. And that can become a misdemeanor if the child is in between the ages of 12 and 15, or if the recipient transmits the photograph that was sent to them. General theme and intent of this is that the legislature intended to exempt teenagers 18 and below from felony prosecution for sexual exploitation of a child in all but the rarest of circumstances. The problem is, no one in Robert Grant's case knew about these exceptions. Not the prosecutors who charged him, not the judge who oversaw his case, and certainly not the defense attorney who advised an 18-year-old Robert to plead to 2 counts of felony attempted sexual exploitation of a child for him asking a 16-year-old girlfriend to send him videos of her breasts. That is an injustice. It's the type of injustice that happens when attorneys and judges don't read the statutes that are applicable to the case before them. And this court in State v. Dinkle recognized that when that injustice happens, we need to fix it. We reject the premise that a reasonable attorney could miss a statutory defense or a statutory provision. Instead, we say we recognize this will happen. Lawyers will miss things. Judges will miss things. But our litigants' lives should not suffer because of our oversight. Those are powerful words, but as long as we are normalizing the summary denial of post-conviction motions, they're just words. Because I promise you, Robert Grant has suffered, languishing in prison, waiting for this appeal to resolve. This is not simply a case where Robert slipped through the cracks and nobody noticed. This is a case where the lower court saw that Robert fell through the cracks, and instead of lifting him up, they attempted to pave over that crack with Robert still inside. It is an injustice that everyone back in 2021 missed this, but it is unconscionable that we are 4 years into Robert's prison sentence, and he still hasn't had the opportunity to even argue to withdraw his plea. So today we're asking this court to reverse the decision of the Court of Appeals and remand this case for a long overdue evidentiary hearing on Robert's motion. And one of the things that's particularly frustrating about this case is this should have been a really easy question for the district court. Robert alleged his counsel failed to provide him advice on an applicable statutory defense. State v. Dinkle pretty much controls the law on that. We have a fact question. We should have brought in the counsel to discuss that, to ask them, did you advise that? If not, why not? And then let the court rule on whether or not Robert should be given permission to withdraw his plea. But we didn't get that, either at the district court or the Court of Appeals. Instead, we got a very convoluted interpretation of these Romeo and Juliet statutes that practically renders them meaningless. Because if images of teenage breasts are not included within the teenage sexting statute, it is hard to imagine what specifically would be. In my petition, I detailed sort of the micro of every step of the Court of Appeals decision that I believe they erred in. We may not have time to get to all of that. Broadly, though, the problem they had is they lost sight of the intent of the legislature. When the legislature enacted these statutes, they did so with the intent to exempt teenagers from our child pornography statutes. That is what they intended to do. Instead, what we have from both the district court and the Court of Appeals is effectively an interpretation that turns this into prosecutorial discretion on whether or not which one of these crimes gets charged. But that's not the law we made. We used mandatory language. It might have been the law if we had just enacted these juvenile sexting statutes without amending sexual exploitation of a child. But we didn't. Opened up sexual exploitation of a child, except as provided in KSA 215610 and 215611. Sexual exploitation of a child is. That means we don't ever consider sexual exploitation of a child until we are positive the conduct is outside of the 4 corners of our Romeo and Juliet statutes. And if we look in there, it's more mandatory language. It shall not be unlawful for a person who is less than 19 years of age to possess a visual depiction of a child in a state of nudity who is 16 years of age or older. That's what Robert's alleging. At worst, He transmitted it because our definition of transmission includes requesting for an image. That is the literal crime that he pled to in the complaint. He asked his girlfriend to send him videos of her nude breasts.
Is there anything in the complaint or in the factual basis of the plea that gives us an idea of the images beyond that description at all?
No, I don't.
In other words, are there any descriptions of the images themselves that would challenge your characterization of them?
No, I think the problem here is, well, there wasn't an evidentiary hearing for these to be admitted. So any description is going to be based on secondhand hearsay to begin with. And those are all going to be fact questions for the district court judge and a jury, even if they do. Regarding what the description would have to be, essentially, the only things, if we have the applicable age range, that could bring it into sexual exploitation of a child is 5 things. It have to be either sex, sodomy, sadomasochistic abuse, masturbation, or image of somebody under the age of 12. Anything else gets covered by the Romeo and Juliet statutes. And as far as whether or not these images constitute that, that needs to be resolved by the district court, who has an opportunity to see it, not the 2 Court of Appeals panel judges who've never seen these photos.
Right. But I was thinking one opportunity where that might have happened was at the plea when there's some discussion of the factual basis. But in my review of the record, it looked just very generic, high level, just an admission to the statutory, the specific statute.
My recollection was it was pretty bare bones. But even if it was something that could have arguably fallen into one of those categories, none of that changes the fact that his counsel had an obligation to know the applicable defenses, present that to Robert, and let Robert make a knowing decision on whether or not he wanted to plea or take his chances at trial knowing he had a viable defense.
Let me ask, just for purpose of clarification, let me get to my notes. What this is, this is at its core, a motion to withdraw plea based on ineffective assistance of counsel.
Correct.
Right, okay. So what we're looking at then is not what he pled to, but the 18 counts that were in what I'm going to call the first amended complaint or whatever, not the one that has the attempt, the other one. Okay, there were 18. And so when we're evaluating counsel's performance, we look at that complaint and say, was the attorney, I don't know whether he or she, was the attorney deficient performance in investigating and then discussing with the defendant any kind of defenses or any kind of, this is what we're talking about, is that, right? Not the attempt.
Correct, yes.
Okay. And then when you read the order denying the motion to withdraw plea, and for that matter, that I think the Court of Appeals majority opinion, they talk about sexually explicit conduct as defined in the first statute, which is 5510.
Right.
But there's a different definition, and that one includes photos, right? A naked.
5510 includes photos.
Right. But as you noted, you don't do 5510. The first thing you do is go to 5610 and 5611, which necessarily has a different definition.
Yes.
Of sexual, that does not include,
Correct.
These naked photos or whatever. Is this where the district court and the Court of Appeals erred because they were using the wrong definition?
That is certainly where the district court erred, for sure, based on their ruling. They reviewed the sexually explicit conduct definition from 5510, and as the one that's applicable is going to be the one from 5611.
But 5611 says, as used in
Yes.
5610, I think it says, as used in this statute and in 5610.
Yes, it says in
Right.
both of those
Right.
statutes, yes.
Okay.
The Court of Appeals, I think, eventually gets there. They take a very long winding road to get there where their first error is they conflate the two exceptions, because of course our exceptions have exceptions, and include propensity within that. And then they erroneously interpret the propensity statute to say that it's just prurient interest. And then they take that out of the jury's hand and say that these photos that we've never seen have, we're going to declare they appeal to the prurient interest. And then after all of that, they say, well, so we can't ever decide whether or not photos on their own should get the Romeo and Juliet statute. So we're just going to defer to how it gets charged, which then does kind of bring us back to they're effectively reading the wrong definition.
Wrong definition.
Right, because we cannot go to that definition until we're definitively outside of the scope of 5610 and 5611.
Can I try to simplify all that, at least in my own mind? I read the Court of Appeals decision, the nut of the decision comes on page 5 when the Court of Appeals, and I'm just highly summarizing here, in my reading at least, essentially says that obscene materials do not receive any protection under the Romeo and Juliet law.
Yes,
that's what they said, right?
Right.
And that's why they concluded that your client had no available legal defenses.
Well, sort of, yes. I don't know how they got from this is an obscene material to then has to be charged under sexual exploitation.
Well, that's what I wanted to ask about. Like, is it correct? Or give me your perspective on the statutes themselves with respect to this question. Does obscene material receive any Romeo and Juliet protection?
And before I do, Chief Justice, I see I'm out of time. May I have leave to answer this question?
Yes, you may.
Thank you. Obscene material does not necessarily, no, I don't think it has protection underneath the Romeo and Juliet statute.
Why not?
Because they've accepted it. It says these statutes do not apply to sexually explicit conduct, or apply to a visual depiction engaged in sexually explicit conduct. That's your first exception. Or a visual depiction that constitutes obscenity as defined by 6401. The problem is, first, if it is obscenity, they have to be charged under the promoting obscenity statute, which is another misdemeanor. Robert would be fine with that comparatively. But the second problem is these don't fall under the definition of obscenity. We again have a codified definition of obscenity.
The courts historically, almost to the point of becoming a punchline,
sure,
struggle to define obscenity.
Well,
this is the perhaps ambiguity in this statutory scheme that the Court of Appeals obviously struggled with, and frankly, I am too, because it seems ludicrous to me that you would craft a Romeo and Juliet exception and then say, but obscene materials receive no protection. Because the way the Court of Appeals wrote it, basically the only Romeo and Juliet protection is for baby pictures in a bathtub. Essentially, and they even use that as an example.
Well, they're definitely wrong about that because below the age of 12, the Romeo and Juliet.
Okay, but the point being that the materials has to be, I mean, essentially entirely non-sexual. And the whole point of the Romeo and Juliet exception is to cover sexual materials.
I agree with you.
So help me understand how that works from your perspective.
You are correct. When we look at the obscenity, it's far narrower than I think what you're suggesting. The only thing we add, because again, it's got the four that we talked about earlier: sex, sodomy, sadomasochistic abuse, masturbation, excretory functions, and then lewd exhibition of genitals. That's codified. It has to be codified by Miller v. California. So breasts, the buttocks, those are never going to be able to be obscene or sexually explicit as a matter of law.
Well, the Court of Appeals relied on the definition of obscenity that the average person would find it appeals to the prurient interest.
Right. They used one of the three mandatory elements.
Wouldn't the average person find that these photographs appeal?
I don't know. That's a jury question. I don't think that we're going to I don't think most jurors would say that an image of a female breast is morbid enough to appeal to the prurient interests of, in that, in the way. that-
Really?
Yeah, I don't. I think, I think that the average person,
I'm just concerned, and I don't mean to camp out on that question.
No, it's fine.
But I'm concerned that the obscenity portion of this is, it swallows the exception whole, or it swallows the Romeo and Juliet exception whole, which really is how I read the Court of Appeals opinion.
If there's, again, I'm gonna stand on all three of those prongs of those elements have to be met, both because there's a conjunctive and that's how we interpret it, and because Miller v. California tells us we need all three. So it can't just be prurient interest. It also has to be sex, sodomy, sadomasochistic abuse, masturbation, excretory functions, or lewd exhibition of the genitals. Breasts and buttocks are never going to be able to fall under promoting obscenity because they're not expressly caught.
So you would suggest the Court of Appeals may be erred as a matter of law by relying solely on the prurient interest?
Absolutely. Yes, you need all three. And even there, if it were just prurient interest, that's a fact question for a jury.
Okay.
You know, and doesn't, I took the statute to be codifying the definition of obscenity in sort of the normal First Amendment category, where there's a difference between pornography and obscenity. And so the statute's carving out the obscenity part, which is, you know, not pornography. I mean, am I misreading all this?
I mean, it's certainly carving out.
That's obscenity. It's not pornography.
Right. I suppose I don't know the difference between those two off the top of my head. I've always kind of interpreted obscenity being the way we lawfully regulate pornography that is more obscene, so obscene that it would violate the First Amendment.
Right, but it has to be more graphic.
Yes.
To make it into the obscenity category, and then there's this other category, and it'd be hard to define it, but it doesn't restrict you know, all depictions of sexual activity is not obscene.
Right. And I do think that's maybe where I got lost in my thought on, while breasts wouldn't necessarily be obscene, we see them in movies all the time, and it's not considered a crime to show those movies or anything of those lines. So I don't think contemporary community standards have demonized the image to the point where it can just be governed.
One last question. I started off by saying that this is a case about, you know, basically a motion to withdraw plea and ineffective assistance of counsel. And given all the questions and ambiguities and, you know, if, you know, we don't even have to decide all that, do we? Just given all of that, you know, the question is, did counsel investigate any of this and talk to his client about it?
Given everything we've talked about today, it sure seems like there's a fact question or two to ask.
Yes, thanks.
For all those reasons, we would ask this court to reverse and remand for an evidentiary hearing. Thank you.
Thank you.
May it please the court, Christy Allen, Assistant District Attorney, appears on behalf of the state of Kansas. And I would, for a moment, just like to take the focus back to what Justice Sandridge was talking about. This was a motion to withdraw plea post-sentencing. So we're looking at a manifest injustice standard. In order for a district court to grant a hearing, a summary disposition of a motion to withdraw plea is proper when the defendant's motion does not raise a substantial question of law or tribal issue of fact, and the files and records conclusively demonstrate the defendant is not entitled to relief. And what we have here is a district court. I know there's been discussion of obscenity, but we don't even have to get to obscenity, because the Romeo and Juliet statutes themselves say sexually explicit conduct or obscenity.
Can I back up before we even start to talk about the statute?
Mhm.
Is it true that neither counsel nor the court knew about the Romeo and Juliet defenses in this case?
From preparing for this oral argument, I can tell you that that is not correct. It is not correct that they did not know of the statute. And that leads me to the part of my argument where Romeo and Juliet statutes are not a defense. That's not something you go into court. If you're charged with sexually explicit conduct or sexual exploitation of a child, that is not something you go into court and you say, Judge, we're going to raise this defense. We would like jury instructions that reflect our defense. If you are charged with sexual exploitation of a child, there is a sufficiency element to that where if the state does not prove sexually explicit conduct, then you're acquitted. You're not acquitted because you're 18 years old and you possess a picture of a female breast.
Well, let's
You're-
just call it a carve out then to the sexually explicit,
Okay.
to the crime itself.
Mhm. Okay. But that's still,
I mean, it seems as though nobody thought about this.
and I don't think that's accurate. And speaking with the prosecutor who charged and was ultimately going to take this to trial. And when we talk about this, we keep talking about nude images of a female breast. That's not necessarily the evidence that would have been presented at trial. Granted, we don't know what those images are because they are not in the record. And my
We
understanding,
do know what they are because in the affidavit, whoever wrote the affidavit described each of the 18 pictures.
it described pictures, but what we also have is in his motion to withdraw plea, we have the defendant telling the district court that he has a video of them having sexual intercourse. And sexual intercourse falls within that definition, both definitions of sexually explicit conduct. So when you have the district court judge read that motion to withdraw plea, and he starts with, I have a film of the underage victim and myself having sexual intercourse, I think we get past the images of the female.
That wasn't part of the charging documents, right?
There was nothing specific in the charging documents. That is correct.
In each of the 18 counts, there was no charge for that.
There was nothing specific in the charging.
And for that matter, they used the language of the statute, but in the affidavit, there's nothing about him transferring or promoting or even receiving. It's all about what they found on his phone, which would be possessing, correct?
I think where I would disagree with you respectfully, Your Honor, is the fact that promoting a performance can be enticing someone. Promoting is defined in the statute.
Where was it in the affidavit that he enticed? Nowhere. I've read it twice.
Right, but my understanding is this probable cause, this charging affidavit just sets out the basic images. And so if we were to have a preliminary hearing, then you call in witnesses. It's the only evidence in the case is not just in that charging affidavit. That charging affidavit is what gets your foot in the door to be able to get a charge before the court.
But we don't know that, I mean, you're trying to tell us what would have happened if they'd have had a hearing, I feel. Let's start with the lens we have to analyze whether as a matter of law, defense counsel had an obligation to talk to this kid is based upon the original charges. That's the duty so what we have to do is figure out whether the Romeo and Juliet statutes applied to what was in the original complaint.
Correct. And because that original complaint alleged possession of sexually explicit conduct and promoting the performance of sexually explicit conduct, then the Romeo and Juliet statutes do not apply.
I'm not following what you're saying because the very first thing in this statute says subject to 56, 10, and 11.
It says except as found in, yes,
Right.
yes.
So
And-
don't you, I mean, necessarily when you're charging under that statute,
Mhm.
maybe you don't say it as a defense, but as Justice Stiegel said, it's a carve out. So you have to go first for the state, even improving their case first, has to go to 56, 10, and 11, don't they?
They do, and so there's something more there. There's something more there that caused the charge to be sexual exploitation of a child. When we talk about this, when you talk about the charging affidavit, it's not just female.
Talking
threats.
about sufficiency of the evidence. You go, going back to, as Justice Biles just said, given that, did defense counsel have an obligation to talk to this kid? Was there a duty?
So my response to that, Your Honor, would be that defense counsel had the discovery, knew in theory, what all of the evidence would be, had the interviews with the victim, had the interviews with the defendant. It was more than what was just reduced to that charging affidavit. And so if what he knew was that the Romeo and Juliet statutes do not apply because it's not
Isn't
just.
that a fact question for the judge to decide at an evidentiary hearing on a motion to withdraw?
It could be. It could be.
So you're agreeing that we should remand it for that purpose?
I understand that given the complexity of these statutes, that there would be a desire to remand. My best argument for why no remand is necessary is because the statutes themselves say that that they do not apply to sexually explicit.
But sexually explicit conduct, you're first supposed to go to 5610 and 11. And sexually explicit conduct defined there is different than defined in the original statute.
Correct. It leaves out exhibition in the nude. It leaves out lewd exhibition of genitals, female breasts, or the pubic area of any person. But what I'm saying is when we're here to review the district court's ruling on the motion to withdraw plea.
And he used the definition.
Because the charge was under 5510. He used the definition of sexually explicit conduct in 5510.
He ignored the whole beginning of the statute that says except as provided.
Because he was told by the defendant in his opening paragraph, there is a film of me having sexual intercourse with an underage child. But
it doesn't say that in his order.
It does not say that in his order. But if we're looking at the motion and the records in this case, the motion in this case begins with, we had sexual intercourse. There's a film of us having sexual intercourse. So as the district court judge, he reads that motion in his mind is a film of them having sexual intercourse. And that fits both definitions of sexually explicit conduct.
But again, isn't the problem there that that's just not really what the state charged him with?
Right.
When you say not what the state charged him with, they charge him with possession, and with
based on that whatever comment the defendant made was not the factual basis for the charges in the charging document.
I would concede that it was not the factual basis for the charging document, but that does not mean that would not have been part of the evidence.
Right.
Had they gone to trial, but the defendant himself removed this from trial and by entering this plea. And so I guess my point is when we're looking at the performance of counsel, we want to say that there's no way that this counsel could have looked at these two statutes and not told him about that. But what we don't know is what information that counsel looked at, and perhaps he also knew that the defendant had this film. And so in counsel's mind, I don't have to tell him about this because this is sexually explicit conduct.
But isn't that the reason why?
Here that it needs to go to an evidentiary hearing. I mean, this is the argument the other side should be making, that it would need to go to an evidentiary hearing so we could find out what was in counsel's mind.
But
there's a factual dispute.
But in that plea, in the plea itself, defendant tells us that it's sexually explicit conduct. He states that it's sexually explicit conduct. I understand you may not like
under
that
5610, which includes a naked picture. And that's what he repeats over and over and over.
I don't know that 5610 includes a naked picture.
The definition of sexually explicit conduct, it does.
Sexually
you just said that.
So are you talking about exhibition in the nude? That's your reference to a naked picture? But that can also be more than just a naked picture. And what we have from the charging affidavit is it's more than just a naked picture.
Really? Because I connected all 18 of those pictures where he says, I reviewed image, whatever, to the charging documents, with the dates. And I didn't see anything more than a naked picture.
A 15-second video file where the defendant is lying on top of the juvenile between her legs with a blanket partially over them, Both the victim and the defendant's faces are visible as the camera moves up and the defendant is kissing the victim between her exposed breasts. That's not just a nude
That's not
photograph.
sexual intercourse.
That, I didn't say that it was, Your Honor. That was, I'm not saying that that is sexual intercourse.
Well,
You
what does
also-
it fit under the definition of sexually explicit conduct? Actual or simulated sexual intercourse or sodomy, including genital to genital, oral to genital, anal to genital, oral to anal, whether between the same or opposite sex, masturbation, and sadomasochistic abuse. Which one does that fall under? That video?
That video does not fall under that definition.
Bingo.
But there's more than just when you talk about nude image, this is more than just a nude image. There's action in this image. So it's not that it fits within sexual intercourse, but when we get to, he was charged under promoting a performance. Okay, so this is promoting a performance that we can deem sexually explicit conduct.
Where's the promotion?
He tells us that there was promotion. The
It's not
defendant,
in the charging document. We're not talking about what he pled to or his motion to withdraw plea. We're talking about before any of that happened. Did his counsel advise him based on the 18 count information / complaint? You know, he didn't tell us any of that.
counsel didn't tell us any of that.
No, you're saying that the defendant himself told.
No, I'm saying that if we're reviewing the district court's order denying the motion, part of that motion is the defendant's statements that he has a film. So as the district court judge is
You're
reviewing
making that. That's pure speculation. I mean, when you read the order denying, he doesn't say all that.
It's not pure so you're saying that I'm assuming that the district court judge
Relied
read-
on that particular comment in the motion. He doesn't say that.
I apologize. I guess I assumed that when a district court judge reviewed a motion that they took the information within that motion and analyzed the information provided in that motion.
Even if the district court did, even if the district court said explicitly, you told me this, I'm relying on, I mean, that's error, right? Because that alleged video was not part of the charge that he pled guilty to. It has nothing to do with his motion to withdraw his plea. It might be something you could charge separately, but I just don't see any relevance to that.
So just so I understand, you don't see relevance of the defendant admitting to having more than what was in the charging document?
Because he's making, his motion is, I want to change my plea to what you charged me with. And what you charged this defendant with had nothing to do with that alleged video.
In the charging affidavit, in the affidavit of probable cause, my understanding is the state is not limited to the information in the affidavit of probable cause and presenting evidence at trial.
I think the focus, again, keep wanting to get back to the original charges. And I think we would all agree that a defense counsel has a duty to talk to the client about whether the charges that are alleged apply to the defendant, right?
Yes.
And he's coming in and saying, my lawyer didn't tell me that these charges might not apply to me. So that's, again, you're nodding your head. So, okay, so we all agree that much is there.
That he's claiming that his counsel did not talk to him.
I understand he's playing.
Yes.
You're not
Yeah, no.
agreeing. I know you're not agreeing. I'm just saying that's the claim here.
Yes.
And so how does the district court ignore that for purposes of a summary denial of this motion? Nobody's saying, you don't have really good arguments once you get everybody in a courtroom. The question is, how do you get to a summary denial based when when the client says, the defendant says, I wasn't advised that some of these charges might not apply. And we know as a matter of law, some of them might not apply just based on looking at that and looking at the circumstance. But what else does the district court get to look at to do a summary denial of this application?
My understanding is that when the district court looked at the motion, he saw that he pled to, and I understand.
Doesn't matter how does it matter what he pled to?
I understand. I'm just trying to tell you what was in the order of the district court. The district court reads this and says you pled to promoting or attempting to promote the performance of sexually explicit conduct. Sexually explicit conduct is not covered by the Romeo and Juliet
But
statute.
what does that have to do with the allegation that the defendant hadn't been properly advised about what and I would call it a defense when you would want to say these charges don't apply to my guy. That's a defense. And here the defendant saying, I wasn't told that these things might not apply to me. And so then I copped a plea thinking that I was sunk on 18 charges. That seems to me to be the essence of what's here. So how does the district court get to summarily dismiss that notion?
I apologize if I seem to be.
I'm just saying,
contrary.
So if the district court said, I can dismiss all this because I see what you pled to, then it seems to me it's a fair argument for them to say that doesn't apply to what our motion was. And we can evaluate that.
So the district court said that as a matter of law, because the statutes themselves say it does not apply to sexually explicit.
What you pled to.
That is what the district court said, but the district court can be right for the wrong reasons. And so the district court, looking at the charging document, if he's reviewing the motions and files of the case, which is what he's supposed to do, he can look at what he was charged with. You were charged with sexually explicit conduct. And because you were charged with sexually explicit conduct, the Romeo and Juliet statutes themselves say that they are not available to you.
But I thought you agreed with me. The defense counsel would have a duty to tell this defendant that some of these allegations don't apply to you. As opposed to, there might be some where you get tagged, but there are also some that you might not apply. It seems like that the defense counsel has an obligation to have that discussion with the defendant.
I agree.
Right?
I agree that defense counsel has an obligation to discuss possible defense.
The whole range of what's here.
Correct.
Not just, well, they allege this over here along with 12 other things that don't apply to you, but they did this one. So now there's no duty to advise the client properly. That's where I'm struggling with this.
And my response to that would be the defense counsel also was aware that sexually explicit conduct is excluded by the Romeo and Juliet statute.
How do we know that?
Doesn't the defense counsel have to say that in a hearing? That's all we're getting at here. This is a summary dismissal.
I understand.
We've got a limited universe that we get to look at here.
I understand.
So I'm saying what's within the limited universe? How do we sustain or affirm what the district court did here?
Again, my best argument is just he saw that it was sexually explicit conduct, and as a matter of law, sexually explicit conduct does not apply to the Romeo and Juliet statutes.
So your argument is essentially, even if there's deficient performance, it's not prejudicial.
Correct.
Isn't that circular? I mean, if you're trying to withdraw your plea, you're saying, I'm not guilty of the crime as charged. It seems to me your argument is the district court looked at what he pled to and said, well, if you're guilty of this, then you don't have a defense under Romeo and Juliet. That's entirely circular. The whole point of the defendant's motion is he's saying, I'm not guilty of this.
And the defendant's motion itself says I'm not guilty because I was under 19 and possessed a nude photograph of my 16-year-old. That's what his pro se motion says. His pro se motion requested the dismissal of all charges.
But doesn't it have to be an error of law for a district court judge to deny a motion to withdraw a plea by looking at the charge that was pled to and saying that since you pled to this, you don't have any available defenses? I mean, that's the whole point. He agrees with that. That's why he wants to withdraw his plea.
And I understand, and I agree that the district court's order does reflect the charges that he pled to. But again, a district court can be right for the wrong reason. And if the district court reviewing the charging document sees that it is sexually explicit conduct and reads that there is not sexually explicit conduct does not apply, if there is sexually explicit conduct, then the Romeo and Juliet statutes do not apply. The district court is looking at that, then he concludes.
What factual basis would he have to make that conclusion, draw that conclusion? What possible factual basis could there be?
What possible factual basis for him to conclude that he was charged with sexually explicit conduct?
Maybe we're talking past each other.
I
but
apologize.
Your argument appears to me to be that the district court relied on the charge that he pled to.
And that is what the order states. That is what the order states. Yes.
And I'm struggling to see how that's not an error of law.
Because again, he can be right for the wrong reason.
What's the alternative reason? Maybe that's what I'm struggling with.
That he was charged. So when we talk about the legislative history and council submitted legislative testimony, and in that legislative testimony, it even points out that these statutes are meant as a tool for prosecutors and law enforcement. And so this is a situation where prosecutors and law enforcement review this material. This material is reviewed and charging decisions are made. Charging decisions are made based on the evidence that the state thinks that it can prove at trial. And the state charged more than something that the Romeo and Juliet statute would cover.
What? Yeah, I mean, all they did was say sexually explicit conduct.
And I understand that. And we have the charging affidavit. We don't have the interviews of the victim. We don't have any of that other information. I don't disagree with you. I don't disagree with you.
You're basically just saying trust the state. I mean, that's what it sounds like.
I'm saying that.
So here's how it appears to me. Just try to be bottom line. You've got a charge of sexual exploitation. You've got an 18-year-old defendant, 16-year-old victim. These are very serious charges. This defendant has been in prison for 4 years. I just struggle to understand how. I don't even understand why the state, frankly, is defending this case, just to be blunt. How can it be that the Romeo and Juliet statute is never discussed in such a case?
At what point would it have been discussed?
Well, to begin with, between the defense counsel and his client.
And this goes into, this would have been a reason for an evidentiary hearing because we don't know. We don't know that conversation doesn't happen. You are correct. But the reason that I am here today to pitch to you that it is unneeded is because the language of the statute says that these do not apply to sexually explicit conduct. And what we have was charges of sexually explicit conduct, admitted conduct in the plea that it was sexually explicit conduct. Therefore, the district court reviewed that, found that as a matter of law, since sexually explicit conduct does not apply to the Romeo and Juliet statutes, no evidentiary hearing was necessary. I see that I'm way out of time, and thank you for allowing me to answer your questions. If there are no further questions, we would ask that this court affirm the district court.
Thank you.
Chief Justice, I'm happy to answer any outstanding questions, but would otherwise waive my right.
I've got one. I was thinking about my questions to the state and wondering if I wasn't limiting the universe that the district court had to look at. Okay.
Okay.
So for purposes of the allegation, which is whether the defense counsel talked fully about the original charges, the district court also gets to look at the record of the case, right?
Correct, yeah.
And doesn't that inform, or why, I guess the question to you is, why doesn't that provide additional information within our universe that's being evaluated by the district court? Like, why doesn't that give enough information to be able to summarily deny and say there's no point to this business, which is kind of what summary dismissal is?
Well, in this scenario, I don't see what information within the entire record below would raise to that level. You would have to have, at a baseline, just concrete evidence that he fell outside of the Romeo and Juliet statutes. But even with that, I don't think that absolves the defense attorney's obligation to talk about those defenses with Robert and let Robert make the decision on whether or not he wants to risk trial on the 18 counts or whatever it was while presenting that defense, or take this plea to the 2 counts that he ultimately pled. And it keeps coming back to, there is a fact question about what Robert and his counsel discussed. For our purposes, we have to, since it was a summary denial, we have to assume that Robert is accurate in his assertion that his counsel never discussed these defenses with him. And we need to send that back down for that. I don't think there's anything in this record. Maybe if you have something specific that you want me to address, I can, but I don't think there's anything in this record that would take us out of that.
But you agree that our universe would include the court record?
Yeah, I agree.
In front of the district court as well. I mean, I was kind of narrowing it down maybe unfairly with the state when I was talking about just the original charges. There's a little more to it, I guess.
I do.
What I'm struggling with.
I will put in one caveat, though. The court can't credit assertions in the record. Like, so for instance, the affidavit, it's included there. The state hasn't met their burden to prove what's in that affidavit yet. So I don't think for the purposes of summary denial, the court can just assume that everything in that affidavit is true.
Well, if there were a factual basis for the plea and that factual basis demonstrated images that fell within the definition of sexually explicit conduct, is it fair to say that if that were the case, that any deficient performance was not prejudicial?
I don't think so. And my problem with that is a lot of times people will end up pleading to things that are legal fictions to get the benefit of the bargain. So I don't ever trust a factual basis to be concrete 100% what happened. It's just what the parties are agreeing to move forward. And if you don't have an attorney who,
Well, okay, let's just say, I just assume there is a concrete factual basis. They'd go through the images and make specific findings, and it's clear they fall within the definition of sexually explicit conduct.
say the images were in the record
Yes.
for us to look at.
Yes, yeah, absolutely.
Then yeah, I think maybe the state could have an argument that there wouldn't be prejudice.
It's just your position is that's not what happened here.
That's not what happened here, and I could see an argument that that's still a fact question for the district court.
I'm curious about your response to your client's in his motion to withdraw the plea, as counsel pointed out, where he acknowledges that his phone was used to record himself and the victim having sexual intercourse.
And to be clear, we're talking that the victim recorded them doing that on the phone, right? Isn't that what it says?
It is.
It is, yeah. But what about that acknowledgement that there's that transmission of sexual intercourse?
I think it's a red herring in this case for a few reasons. One, wasn't charged. There's no evidence. We don't have.
I understand all that, but if I'm a district court judge and I'm looking at this and I see that,
Okay.
it completely takes it outside of the Romeo and Juliet exception or law. Do you just ignore that and say, what do you do?
You can ignore that, yes, because it's not going to be that statement, and nothing that Robert says at his eventual evidentiary hearing on this is going to be able to be admitted against him at trial pursuant to the doctrine of unconstitutional conditions, because he is asserting his Sixth Amendment right to effective assistance of counsel. Additionally, you can ignore it in large part because even if it's true, even if the state has one video Robert pled to 2 counts. There's still prejudice from him not getting discussed this, because at worst, he's guilty of 1 count. And with that, thank you for your time.
Okay, thank you. Thank you to both counsel. Court will now be in recess for 15 minutes until 10:45. All right. I will be taking this under advisement. I think I said that.